Thank you, Mr. Hanson. It's a great pleasure to serve under your chairmanship, and I'd like to move that this House has considered Sharia courts in the UK. I'm also extremely grateful for all the members that have turned up. Turning up on a Thursday afternoon when there is not that much business on at a time of local elections shows a devotion to this House and a devotion to the subject that I am particularly grateful for. Now, the genesis of this debate is a report prepared for the Council of Europe at its meeting in January of this year, at which I happened to speak. The report was led. The report was led by a paper prepared by a member, in fact, of the Spanish Socialist Party, which looked at the compatibility of Sharia law with the European Convention on Human Rights. And I want to turn to this topic a little later in my speech. In that report, the UK was singled out for mention, not completely approvingly. And that was for how it was approaching this issue alongside a number of other countries, such as Greece, which has taken a different approach. Now, in approaching this issue, I am well aware that the charge of Islamophobia may be levelled against us for raising this subject. But it is right that Sharia law courts or councils are looked at in terms of their conformity with the European Convention on Human Rights, just as other aspects of UK society are. I'm aware, too, of the independent review into the application of Sharia law in England and Wales, which was produced in February of last year, February 2018. This review was chaired by Professor Mona Siddiqui of the University of Edinburgh and had distinguished lawyers and religious and theological experts on it, and I've read this report with great interest. In the Council of Europe session, the Council called on the authorities of the United Kingdom to do a number of things. And I just want to read out those things, largely without comment, although on one of them I will comment. The first one was ensure that Sharia councils operate within the law, especially as it relates to the prohibition of discrimination against women and respects all procedural rights. The second was to review the Marriage Act to make it a legal requirement for Muslim couples to civilly register their marriage before or at the same time as their Islamic ceremony, as it claims is already stipulated by law for Christian and Jewish marriages. Just on that point, as an aside, I'm aware that there are a number of imams who are also qualified as registrars and therefore can conduct the civil service at the same time as the religious service, just as in the Catholic Church there are a number of Catholic priests that are qualified as registrars and who can do both. But I don't think it's correct to say that there is a legal requirement for this to go ahead. The third point was take appropriate enforcement measures to oblige the celebrant of any marriage, including Islamic marriages, to ensure that the marriage is also civilly registered before or at the same time as celebrating the religious marriage. Next, ensure that vulnerable women are provided with safeguards against exploitation and inform them about their rights to seek redress before the courts in the UK. And the next point was to put in place awareness campaigns to encourage Muslim communities to acknowledge and respect women's rights in civil law, especially in the areas of marriage, divorce, custody, and inheritance. And again, as an aside, I think that there is a lot to be said for putting some emphasis on that particular point and ensuring that we do indulge in awareness campaigns. The next point was to conduct further research. Of course.
Awareness. And like him, I read very carefully the independent Home Office report. And that said this, it said, it is the misrepresentation of Sharia councils as courts that leads to public misconceptions over the primacy of Sharia over domestic law and concerns of a parallel legal system. And whilst, of course, he's been extremely careful in his language today, as I would always expect, strangely enough, the order paper says Sharia law courts, which is precisely what the Home Office report was saying to avoid.
And Hal.
Well, I realise that the independent report calls them Sharia law councils, but we can come on to look at that in a moment. What I was reading out was the Council of Europe's descriptions, which calls them Sharia law courts in that, and I think that we should continue with that, at least for the moment. The next point was to conduct further research on judicial practice of Sharia councils, I've used the term there, and on the extent to which such councils are used voluntarily, particularly by women, many of whom would be subject to intense community pressure in this respect. Now, the Council of Europe committees held meetings with Professor Ruud Peters of the University of Amsterdam, Professor Matthias Roer of Erlangen University in Germany, and on on September the 5th, 2017, it held another hearing with the participation of Mr. Konstantinos Tsitselikis, Professor in Human Rights Law and International Organizations at the University of Macedonia. And also there was Ms. Maktel Zi, a political scientist and an author. Finally, the committee did also hold an exchange of views with Professor Mona Siddiqui, who I've already mentioned, and I'm pleased that they did that. But as Professor Sandberg from Cardiff University and Frank Cranmer of the University of Durham have recently put it, and I quote, "The issue of concern is whether people are pressurized into the form of alternative dispute resolution provided by Sharia councils, and the resolution of the Council of Europe distinguishes between situations where Muslims submit voluntarily and those where they submit under social pressure." But it goes on to comment that the report doesn't pursue that any further. But that is, however, the nub of the issue. And again, quoting from the same authors, a decision to use a religious authority for dispute resolution which is genuinely voluntary on the part of both parties should be no more objectionable than any other form of alternative dispute resolution, provided that it also conforms with UK law. Now, as the Council's report makes clear, Sharia law is understood as being the law to be obeyed by every Muslim. It divides all human action into 5 categories: what is obligatory, recommended, neutral, disapproved of, and prohibited. And it takes 2 forms of legal ruling, designed to organize society and to deal with everyday situations. And it also has a legal opinion intended to cover a special situation. So Sharia law is therefore meant in essence to be a positive law enforceable on Muslims. While most states with Muslim majorities have inserted a provision referring to Islam or Islamic law in their constitutions, the effect of these provisions is largely symbolic or indeed confined to family law. These religious provisions may have a legal effect if raised in the courts, and a political effect if they intrude into institutional attitudes and practices. Now, I shall be looking at the general principles of Sharia law in relation to the European Convention on Human Rights, and particularly Article 14, the prohibition on discrimination on grounds such as sex and religion, and Article 5 of Protocol number 7 to the Convention, which establishes equality between spouses in law. There are other aspects of the Convention which may also have an effect as well. In Islamic family law, men have authority over women because God has made the one superior to the other. And it goes on to say that good women are obedient. It encourages women who stray from these norms to suffer punishment. In Sharia law, adultery is strictly prohibited, and legal doctrine holds that the evidence must take the form of corroborating testimony from other witnesses to provide an individual's guilt. In the case of rape, which is seldom committed in public before 4 male witnesses who are good Muslims, punishing the rapist is actually quite difficult, if not actually impossible. And in practice, this obliges women to be accompanied by men when they go out and is not conducive to their independence. In respect of divorce, under Islamic law, a husband has a unilateral right to divorce, although this can be delegated to the wife. And a wife can therefore exercise her right to divorce. Otherwise, a wife may initiate the divorce process, but only with the consent of her husband by seeking what's known as a khula. In this case, the wife forgoes her dowry. In cases where the husband has deserted the wife, has failed to cooperate with the divorce process, or is acting unreasonably, the marriage may be dissolved. But that can only be dissolved by a Sharia ruling. Hence, while divorce by mutual consent is enshrined in Islamic law, the application must in this case come from the wife, since the husband can repudiate his wife at any time. There is also the question of equal rights regarding divorce arrangements, such as custody of children. For division of estate amongst the heirs, distinctions are made according to the sex of the heir. A male heir has a double share, whereas a female heir has a single share. In addition, the rights of a surviving wife are half those of a surviving husband. Non-Muslims do not have the same rights as Muslims in criminal and civil law under Sharia law. For example, in terms of the weight attached to their testimony in court, which is discrimination on the grounds of religion, within the meanings of Article 9 and 14 of the Convention. The European Court of Rights had the chance to rule on the incompatibility of Sharia law with human rights in the early 2000s. And this was contained in the judgment of the Welfare Party and Turkey, a case that held that Turkey, like any other contracting party, may legitimately prevent the application within its jurisdiction of private law rules of religious inspiration that are prejudicial to public order and the values of democracy for convention purposes, such as rules permitting discrimination based on the gender of the parties concerned, as in polygamy, and privileges for the male sex in matters of divorce and succession. In this particular case, the decision by the Turkish Constitutional Court to order the dissolution of the Welfare Party, which advocated the introduction of Sharia law, was held to be compatible with the Convention. And the court clearly affirmed the following, that it is difficult to declare one's respect for democracy and human rights, while at the same time supporting a regime based on Sharia, which clearly diverges from Convention values, particularly with regard to its criminal law and criminal procedure, and its rules on the status of legal women and the way it intervenes in all spheres of private and public life in accordance with religious precepts. With respect to Sharia law itself, the court expressly stated that the political party, whose actions seem to be aimed at introducing Sharia in a state party to the Convention, can hardly be regarded as an association complying with the democratic ideal that underlies the whole of the Convention. And the court, though, has ruled that Sharia law is not, while it is incompatible with the Convention, it doesn't obviously stop there, because there is no absolute incompatibility between the Convention and Islam, since the court has also recognised that religion is one of the most vital elements that go to make up the identity of believers and their conception of life. Accordingly, the court's relatively firm position should not be taken as a rejection of all elements of Sharia or of Islam as a whole, while taking into account the existence of structural incompatibilities between Islam and the Convention, which, as far as Sharia law is concerned, are sometimes absolute and sometimes relative. It is also likely that a large number of cases concerning the position of Muslim women under Islamic law never come before the ordinary courts or indeed before the European Court of Human Rights, because women are under enormous pressure from their families and their communities to comply with the demands of the informal religious courts. In such cases, there arises the question of whether to use the concept of public order to refuse to recognise or indeed enforce discriminatory decisions, even if they are not challenged by the women concerned. Now, there is currently no single accepted definition of the term Sharia Council in the United Kingdom. In the UK, these bodies generally provide advice and attempt to resolve disputes relating to family or personal issues, according to the principles of Sharia law. However, little is known about their work, which is conducted in private, and decisions are not published, leading to a lack of transparency and accountability. The actual number of Sharia courts operating in the UK is also uncertain. However, a study by the University of Reading identified 30 groups involved in this type of activity, while a report by the think tank Civitas estimated that at least 85 groups are operating, although this figure also includes informal tribunals run out of mosques or indeed online forums. Sharia councils provide a form of alternative dispute resolution. And alternative dispute resolution is something that I am very familiar with, having chaired the all-party parliamentary group on alternative dispute resolution for the last 3 years. Now, in this case, it exists where members of the Muslim community voluntarily consent to accept their religious jurisdiction. Whilst marital issues and granting Islamic marriage divorces account for around 90% of the work undertaken by Sharia councils, they also advise in matters of law, including issues of inheritance, probate and wills, and Islamic commercial law contracts, and provide mediation, counselling, and indeed religious ruling services. Sharia councils are not considered part of the British legal system. They are not courts, and their decisions are not legally binding. However, despite having no judicial authority, some councils see themselves as authoritative on religious issues, and the power of Sharia councils lies in how they are perceived by their communities. A significant number of Muslims do not have a marriage recognised under British law. Those who do not register their marriage under civil law, and some who have been married abroad, have little redress available to them, as under British law, their position is similar to that of unmarried cohabitants, who have very few financial remedies upon the breakdown of their relationship. A significant number of Muslim couples fail to civilly register their religious marriages, and therefore some Muslim women have no option of obtaining a civil divorce. Some women may have no other option but to obtain a religious divorce, for which the judgment of a Sharia council is normally required. Furthermore, even in cases where women have a civil law marriage, some may seek the decision of a Sharia council for reasons of self-identity or community standing, to provide reassurances that they have the religious freedom to remarry within their faith. Those who obtain a civil divorce but not a religious divorce may find it difficult to remarry. This position is sometimes referred to as a limping marriage. One of the experts invited before the committee to testify was a Ms. Z, who denounced what she described as marital captivity. There are numerous reports citing examples of how Muslim women have been discriminated against by Sharia councils. Examples of such discrimination include women being pressured into mediation, including for victims of domestic abuse, greater weight being given to the husband's account of reasons for divorce, women not being questioned by council members, who are almost all men, and not being questioned in an impartial manner and feeling blamed for the breakdown of the marriage, and unjustified requirements to pay back their dowry. There have also been allegations made that Sharia councils have issued discriminatory rulings with regard to child custody, and the Casey review cited claims that some Sharia councils have been supporting the values of extremists, condoning wife-beating, ignoring marital rape, and allowing forced marriage. And researchers indeed were told that some women were unaware of their legal rights to leave violent husbands and were being pressurized to return to abusive partners or attend reconciliation sessions with their husbands, despite legal injunctions in place to protect them from violence. However, the majority of the evidence is anecdotal, as very little empirical evidence has been gathered in relation to users of Sharia councils, and further research in this area is therefore necessary. And I'm aware that the Home Affairs Select Committee did do some work in this area. And mechanisms are required to provide safeguards and ensure that vulnerable women are not exploited or put at risk. Many of these women are also not aware of their rights to seek redress before the British courts. Now, Sharia Council should not be confused with arbitration tribunals. The Muslim Arbitrational Tribunal, abbreviated to MAT, was established in 2007 under the Arbitration Act of 1996. The MAT operates within the framework of British law, and its decisions can be enforced by civil courts, provided that decisions have been reached in accordance with the legal principles of the British system. The legal authority of the MAT comes from the agreement of both parties to give the tribunal power to rule on their case. And in cases where decisions do not conform to the principles of British law, they may simply be quashed. Moreover, the 1996 Act cannot be used to exclude the jurisdiction of the family law courts. The MAT can therefore conduct arbitration according to Islamic personal law on issues such as commercial and inheritance disputes. Now, many of these issues were looked at by Baroness Cox, who introduced an arbitration and mediation services bill back in 2011, and I will leave members of this House to look at that. But turning now briefly to the independent review, this review was set up because Sharia courts are deemed to be discriminating against women, as I have outlined. And there were three recommendations. The first was to ensure that civil marriages are conducted before or at the same time as the Islamic marriage, in line with the way that most Christian and many Jewish marriages are. They need to make it a requirement for Muslim couples to civilly register their marriage. And there were also consequential changes to divorce. If I skip one of the recommendations and go to the third recommendation, which was to carry out some regulation of Sharia courts. Now, the government has declined to do so for the very obvious reasons that to do so would legitimise the courts as part of the judicial establishment, which it has no intention of doing. To go back one, the second recommendation was a general awareness campaign to acknowledge women's rights and to inform women of these rights. Arbitration that applies Sharia law in respect of financial or child arrangements would fall foul of the Arbitration Act. And there are a number of bad practices that have been set out in the independent report. The inappropriate and unnecessary questioning in regards to personal relationship matters. A forced marriage victim was asked to attend the Sharia Council at the same time as her family was. And the insistence on any form of mediation as a necessary preliminary. Women were also being invited to make concessions to their husband in order to secure a divorce. And lengthy processes were in place so that while divorces are very rarely refused, they can be drawn out. And there are a number of other faults with the system: inconsistency, no safeguarding policies, no clear signposting, and even with a decree absolute, a religious divorce is not always a straightforward process. Adopting civil legal terms inappropriately, leading to confusion. Very few women as panel members of Sharia courts, and panel members sitting on Sharia courts who have only recently moved to the UK and therefore have no understanding of the UK system. One argument that is often proposed is that based on the evidence of discriminatory practices in some Sharia councils, they should all be shut down and banned. The main problems with this argument is that one cannot implement a ban on organisations which can be set up voluntarily anywhere and which operate only on the basis of the credibility given to them by a certain community. The evidence the review has heard indicates that women using Sharia councils do so almost solely to obtain religious divorces for a number of different reasons, for community acceptance of the divorce and their own remarriage hopes. Now, in conclusion, it is clear from all the evidence that Sharia councils are certainly fulfilling a need in some Muslim communities. There is a demand for religious divorce, and this is currently being answered by the Sharia councils. This demand will not simply end if the Sharia councils are banned and closed down, and could lead to councils simply going underground, making it even harder to ensure good practice and the prospect of discriminatory practices and greater financial costs more likely and harder to detect. And I think that the main points that I would again refer to, Mr. Hanson, is that there needs to be acceptance of the law of the land, as there is within other communities, and particularly within the Jewish community, where members of the Jewish community do accept that British law overrides their own religious law. And it is impossible to understand why someone would enter a Sharia court voluntarily when they know that they're going to be under pressure to conform with whatever is said there. And I discussed this with another minister who had better remain nameless today, who was actually incandescent about Sharia courts. And she told me to warn the minister not to put up a mealy-mouthed response to it, or otherwise she would be after him. I just mentioned that as an aside for this. Not that I want to influence at all what the minister is going to say, but I do think that it is a very good indication that, particularly amongst women, who have, and this particular minister was a Muslim lady, particularly amongst these people, the effect of Sharia courts is quite controversial, and I'm glad that the Home Affairs Select Committee did take evidence on this. So thank you, Mr. Hanson.